Can I come in, ma'am? Sir? Good evening, sir. Good evening, ma'am.
Please seated.
Thank you, ma'am. Thank you, sir.
So, Shashwat then,
Yes, ma'am.
please tell about yourself.
Uh, so, ma'am, I belong to Bhopal, and I done my graduation from Hidayatullah National Law University, and I graduated in 2019. And from then, I was preparing for judicial service examination, and I have appeared in two examinations: MP Judiciary and Delhi Judicial Services. And in MP Judicial Services, I went to the interview stage, and unfortunately, I couldn't clear the interview stage. And the Delhi Judiciary, I'm still in the process. I have written the mains examination, which was held in June, and I'm still awaiting the result for it.
So, as I can see, you are from HNLU.
Yes, ma'am.
So, वहाँ पर तो काफी सारे placements होते हैं,
Yes, ma'am.
अच्छे law firms में होते हैं. So,
Yes,
why you
ma'am.
have not chosen your career option in law firms? Why judiciary?
Ma'am, actually, there are two reasons because of which I didn't choose any other law firms. So, during my internships, I explored other options, and I thought that these are not my cup of tea. And then I decided to go either for litigation and for judicial services. And then I started preparing for judicial services, and thereafter I developed an interest in the. I got the hold of law actually when I started preparing for it, and then I developed an interest in that field, and then I decided to go for judiciary with my whole heart. And also, my father wanted me to be a judge. That's why.
Okay, Shashwat, tell us 5 of your qualities which you think are best suited for being a judge.
So, first thing which I think I developed in the process only, that is patience. Second is perseverance, which is required for any aspirant. And third thing, I think I have honesty in myself, that with myself also and with my work also, that I don't like to delay things, or I want to work with all my sincerity. And the fourth thing, I think I can serve well in that institution, and I can do justice with it. So I think.
So we are still waiting for the 5th quality.
And the 5th quality, and I'm hardworking. I can work at least for 12 hours a day without any.
Okay. So Shashwat, as I can see, you are honest. That you are telling that it is one of your qualities, that you are very honest. So should we presume that you are honest, or you will need to have adduced some evidence so that we can believe you are honest?
Sir, I think I don't have any particular sort of evidence for it, but as far as what I have been told by my friends, and what I have been told by my friends, and my personal observation about myself, that I don't like to lie. I don't feel good if I do any such things which makes me feel that I have lied and I'm not doing. What should I? That's it.
Suppose, Shashwat, this is the precondition or the prerequisite for your selection, that you need to convince us that you are honest. So how would you prove before us that you are honest? And what does the Evidence Act says about it?
Sorry, sir.
Okay. Shashwat, apart from your qualities, tell us 2 things about you that you think it is not suited for being a judicial officer.
In me?
Yeah, in you.
So, one thing I am very much concerned about is the location in which I will be posted. I've born and brought up in an urban area, and I've been always a kind of person who likes to hang out and go to places, some fancy places. And if I get into the judicial services examination in that institution, and we have to follow some protocols, and we cannot go out and hang around with friends like just otherwise we can do.
So you'll change this quality of yours, or
Yes,
you'll
sir.
continue with?
No, sir. I'm willing to sacrifice this quality of mine. This is not the quality, or like this is my hobby kind of thing, I can say.
All right, all right. So, Shashwat, what are your favorite subjects?
I like CRPC better.
Okay. So let's discuss CRBC a little bit. Shashwat, tell me, if a person who's already undergoing sentence, who's serving the sentence, and he comes up before you for granting of bail, what are the provisions under CRPC for such person, and what are the grounds on which you can grant bail to such person?
So basically, bail is granted only under trial prisoners who is undergoing trial, and to ensure his personal liberty. And after conviction, there is only one ground in which he can apply for bail, when he has to appeal. So as per section 389 of the code, so when a person wishes to appeal, or has appealed, so there are appellate authority can also stay his execution and grant him bail on the condition that he fills the bond as 437A, and under the same section 389 only, if the lower court, the court which has sentenced him, so if the person is willing to appeal and he files an application to the court that he is willing to appeal, and he has been convicted only for offense for 3 years only, and the offense is bailable, and the person is already on bail while the during the trial at the time of judgment, then the lower court also shall grant him bail.
Shashwat, 389(3), as far as I remember, it relates only at the time of conviction. And when person is already serving the sentence and he has come up before you for the suspension of the sentence, what you think should be the grounds on which you will grant him bail?
Sorry, sir, grounds?
Grounds for granting bail to such person. Whatever you have told, these are the sections which relates to granting of the bail, because these are the powers which is given to you under these sections. For exercising these of the power, these are discretionary powers. For exercising these powers, you need to have certain grounds. What are those grounds we want to know?
So the grounds, as far as I can recall, the ground is to if the person wants to appeal, and then he can apply for bail.
I think any person who is serving the sentence definitely goes for the appeal. So every person who has filed an appeal comes up before you for the grant of bail, you'll give them the bail?
No, sir. It also depends, like what is his his antecedents and his other behavior.
So there needs to be certain criteria.
Yes, sir, it's upon the discretion of a court, and it depends on the facts of fact basis, that whether the person is behaving properly in the court, and whether he has any antecedents, and what is his nature.
Are you aware of any guideline given by the Supreme Court in this context?
No, sir. I'm sorry, sir.
Okay.
शाश्वत, जैसा कि आपने बताया कि आप दिल्ली का भी आपने एग्ज़ाम दिया है और अभी प्रोसेस में है, तो फिर अगर दिल्ली में आपका सिलेक्शन होता है तो उस कंडीशन में आप क्या करोगे?
दिल्ली में अभी तो सब उतना दूर का मैंने सोचा नहीं है, बट सिलेक्शन होता है तो फॉर श्योर मैं दिल्ली जुडिशियल सर्विसेज ज्वाइन करूंगा. मेंस में सिलेक्शन होता है सर कि फाइनल सिलेक्शन होता है?
फाइनल सिलेक्शन इज फाइनल. तो फिर हम आपको क्यों सिलेक्ट करें?
सर, whatever comes first, I will choose that. Honestly.
ऑनेस्टली अभी आपने कहा आप ऑनेस्ट हो, फिर आपने कहा दिल्ली में हो जाएगा तो मैं उसको ज्वाइन कर लूंगा. अब आप कह रहे हो जिसमें पहले हो जाएगा मैं उसमें ज्वाइन कर लूंगा, तो फिर हम क्या माने?
सर मैं दिल्ली जुडिशियल सर्विसेज चूज करूंगा.
तो चलिए, सीपीसी आप समझते हैं? सीपीसी के
जी.
बारे में बात करें आपसे.
जी.
अगर डिफेंडेंट डब्ल्यूएस पेश नहीं करता तो आप कैसे प्रोसीड करोगे? क्या क्या ऑप्शन है आपके पास प्रोसीड करने के लिए?
Let me start my proceeding. सर ऑर्डर 9 के तहत उसकी या तो डिफेंडेंट और रिटन स्टेटमेंट प्रोड्यूस नहीं करता है तो बाय डिफॉल्ट कोर्ट के डिस्क्रिप्शन पे है। अगर प्राइमा फेसी एविडेंस प्लेंटिफ प्रूव करता है जिससे बैलेंस ऑफ प्रोबेबिलिटी उसके फेवर में टिल्ट होती है तो कोर्ट प्लेंटिफ के फेवर में जजमेंट दे सकता है ऑन द डिफॉल्ट।
ये बात कहाँ लिखी हुई है, ऑर्डर 9 में?
सर अभी मैं एग्जैक्टली रिकॉल नहीं कर पा रहा हूँ बट मेरे को लगता है ये ऑर्डर 9 में ही मेंशन होनी चाहिए। डिफॉल्ट होता है जब
डिफेंडेंट ने WS पेश नहीं किया और डिफेंडेंट अपीयर ही नहीं हुआ, इन दोनों में क्या डिफरेंस है? ये कहाँ कहाँ मिलता है, ये बात कहाँ लिखी है, इसका इफेक्ट क्या होगा, ये सब कहाँ मिलता है?
सॉरी सर आई कैन नॉट रिकॉल राइट नाउ।
शाश्वत, रिमांड क्या होता है?
सर रिमांड सीआरपीसी के अंडर सेक्शन 167 के अंडर और 309 सेक्शन 309 के अंडर दिया गया है। रिमांड होता है कस्टडी, बेसिकली कस्टडी जब आप अक्यूज की कस्टडी आप या तो पुलिस कस्टडी या जुडिशियल कस्टडी में डालते हैं तो जब उसको कस्टडी में लिया जाता है तो उसको बोलते हैं रिमांड में लेना।
व्हाट इज एडजस्टिव जेनेरिस, शाश्वत?
सर एडजस्टिव जेनेरिस का लिटरल मीनिंग होता है ऑफ द सेम काइंड। तो व्हेन समथिंग इज ऑफ द सेम काइंड, टू थिंग्स आर ऑफ द सेम काइंड, so we cannot say it's adjustum generis।
तो अगर मैंने आपसे ये पूछा, डिफेंडेंट के बारे में पूछा, WS के बारे में पूछा, जो कि CPC के क्वेश्चंस थे,
जी सर,
तो जो रिमांड में पूछ रहा हूँगा वो
Okay.
CPC का होगा या CRPC का होगा?
सर CPC का होगा।
ओके, तो CPC में रिमांड कहाँ मिलता है, क्या होता है रिमांड?
सर इसमें CPC के टर्म्स में रिमांड होता है व्हेन द appellate court sends the case back to the trial court, when under section 107 of the code, the appellate court can remand the case and send it back to the trial court for
रिमांड के बारे में किसी ऑर्डर में भी कहा है क्या कि
So
ऑर्डर
41 में ऑर्डर 41 में जब 10 सेक्शन 107 ऑर्डर 41 के किसी पर्टिकुलर रूल, आई थिंक 27 या 29 रूल है 41 का, जिसमें जिसको सप्लीमेंट करता है सेक्शन 107, तो आई थिंक उसके अंदर जो प्रोसीजर समझाया गया है रिमांड का उसमें समझाया गया है।
इंजंक्शन क्या होता है शाश्वत?
सर इंजंक्शन एक ऑर्डर होता है कोर्ट का जिससे स्टे, बेसिकली जो भी प्रोसीडिंग्स चल रही होती है उसको या फिर किसी भी पर्टिकुलर एक्ट को स्टे कर सकती है कोर्ट।
स्टे और इंजंक्शन एक ही होता है?
सर टेक्निकल मीनिंग डिफरेंट होते हैं। स्टे जब होता है तो स्टे बेसिकली किसी प्रोसीडिंग्स का किया जाता है, कोई जुडिशियल प्रोसीडिंग्स होती है या फिर कोई स्टेट गवर्नमेंट का कोई एक्ट होता है तो उसको स्टे करता है, उसके अगेंस्ट इंजंक्शन ग्रांट नहीं किया जाता है। इंजंक्शंस प्राइवेट पार्टीज के एक्ट के लिए ही ग्रांट किया जाता है। टेक्निकली दिस इज द डिफरेंस।
अगर किसी के अगेंस्ट इंजंक्शन ग्रांट किया है और उसके बाद भी वो इंजंक्शन के ऑर्डर को ब्रीच करता है तो क्या इफेक्ट होगा?
सर ऑर्डर 39 रूल 2 में इसका इफेक्ट दिया गया है कि अगर किसी के अगेंस्ट इंजंक्शन ग्रांट किया गया है और वो ब्रीच करता है तो उसकी या तो प्रॉपर्टी अटैच की जा सकती है या तो फिर उसे जेल में भेजा जा सकता है, सिविल इम्प्रिजनमेंट में।
कितने समय के लिए प्रॉपर्टी अटैच हो सकती है मैक्सिमम?
1 साल तक के लिए।
1 साल, ठीक है।
शाश्वत, क्या एपिलेट स्टेज पर एडिशनल एविडेंस दिया जा सकता है व्हेन इट इज नॉट बेस्ड ऑन मेरिट्स? व्हाट आर द सर्कमस्टेंसेस जब आप एडिशनल एविडेंस दे सकते हो?
मैम एडिशनल एविडेंस बहुत ही कम केसेस में अलाउ करती है अपेलेट कोर्ट, बट 2 सर्कमस्टांसेस, जबकि ऐसा एक सर्कमस्टांस ऐसा है कि जो एविडेंस प्लेंटिफ या जो अपेलेंट है उसके केस के लिए बेनिफिशियल हो सकता है और मेरिट्स पे जिस पे डिसीजन दिया जा सकता है उस एविडेंस के बेसिस पे, और वो एविडेंस जो अपेलेंट या फिर जो भी पार्टी प्रपोज कर रही है देना उसके नॉलेज में नहीं था। आफ्टर ऑल द ड्यू डिलिजेंस विच ही कुड हैव डन, तब तक उसको नहीं पता था और दिस एविडेंस केम अप आफ्टर द डिसीजन ऑफ द lower court, which is so much have so much importance that appellate court thinks this can serve the case or can help the court to dispose of the case on the merits, and it should not cause prejudice to the other party.
कॉन्स्टिट्यूशन पढ़ा है आपने?
जी मैम.
व्हाट इज आर्टिकल 311?
Ma'am, Article 311 basically provides a safeguard against the doctrine of pleasure, which is given under Article 310. Article 311 provides that whenever there is a proceedings against a civil servant who is being dismissed on as per Article 310, then he should be given the fair chance to the right to be heard, and he should be given the chance to present his case in the departmental inquiry that will be conducted before removing him.
What if the opportunity of being heard नहीं दी गई है public servant को and the decision is final? In that case, what recourse does the public servant have?
First of all, he can file any civil remedy, civil suit in any civil court, and secondly, he can apply to a high court or a supreme court under 226 and 32 respectively.
What if
Article.
there is a national interest involved?
So then, if the national interest is involved, then he can be dispensed with the inquiry. As per if the president and the governor is satisfied that for the national interest and for the security of state, the inquiry is not required, then he can dispense with the inquiry.
Are you sure about this?
Yes, ma'am.
मान लीजिए एक व्यक्ति है एंड ही हैज अ हार्ट एलिमेंट, और डॉक्टर ने उसे बोला कि अगर कोई भी शॉक की बात उसे बताई जाएगी तो इट कैन रिजल्ट इन हिज डेथ. व्हाट इफ वाई जो दूसरा पर्सन है नोज अबाउट दिस फैक्ट एंड वो उसे जाकर कुछ ऐसी बात बताता है जिसके कारण उसको शॉक लगता है एंड उसे हार्ट अटैक आता है एंड ही डाई. तो यहाँ पर क्या ऑफेंस होगा?
Ma'am, in my opinion, this offence will fall under explanation 1 of section 299. As the explanation says, if the death is caused by any injury or any act of the person, which to explanation 1 में बोला गया है कि अगर कोई एक व्यक्ति है जिसको बॉडी इन्फॉर्मिटी है, ऐसी कोई डिजीज है, डिसऑर्डर है, और उसकी डेथ को एक्सेलरेट किया जाता है ऐसा कुछ बोल के कि जिससे उसकी बॉडीली इन्फॉर्मिटी को इम्पैक्ट किया जाए, तो और उसकी डेथ एक्सेलरेट होती है, देन द पर्सन हु हैज कॉज्ड द एक्सेलरेशन कैन बी हेल्ड लायबल फॉर कल्पेबल होमिसाइड.
व्हाट इज द ऑफेंस? आर यू श्योर कल्पेबल होमिसाइड होगा ये?
Ma'am, in my opinion, yes, because I have read this case of Bhupender Singh versus Punjab. In that case, the facts were similar. In that case, also the accused said some words, did some acts by saying some words to the deceased, and the disease was going under the same ailment, and because of the words of the accused, he died, and the Supreme Court held that the act of acceleration would also include the words spoken by the accused.
Relevancy and admissibility क्या होती है?
Ma'am, relevancy is any fact will be said to any relevant when it falls under section 5 to section 55 of the Indian Evidence Act, as per section 3 of Indian Evidence Act. And admissibility is whenever the court sees fit and that this particular evidence is proving any particular fact, and then it admissible, and then it makes it admissible in the court, and that with that evidence any fact can be said to be proved.
What are the specific sections that talk about admissibility?
I cannot recall any specific section which talks about admissibility. Sorry, I don't think there are any specific sections which say that particular things can be admissible.
Shashwat, whole Evidence Act is based on admissibility only, and believe me, there are sections which talks about admissibility. Likewise, I want to add something to the question which my friend has asked. tell me whether the Evidence Act is a procedural law or a substantive law.
So it's a procedural law, and it's also said to be an adjective law. So hence it's a procedural law because it defines it guides the courts to how to deal with some evidence and how to deal with evidence and makes it admissible. But the admissibility per se, as per 136, if we are talking about, it depends on the discretion of the court. Judge will decide whether the particular evidence is admissible or not.
Now, my question relates to whether the Evidence Act is procedural in nature or substantive in nature.
It's procedural, sir.
Procedural in nature. How it is procedural?
So as it defines the facts which can be admissible, and it sometimes says for example, order of examination is given under for section 137.
Order of examination and what is evidence, that is provided by the Evidence Act. Evidence है क्या? Basically Evidence Act आपको ये बताता है. Evidence लिया कैसे जाएगा, इसका क्या process होगा, ये कहाँ पता चलता है हमें? CRPC and CPC.
Okay, sir.
कि एविडेंस बताता है कि एविडेंस एक्ट बताता है कैसे एविडेंस लिया जाएगा.
एविडेंस एक्ट
एज फार एज आई नो इतना ही बताता है कि एविडेंस क्या है. कहीं पे एविडेंस एक्ट ये बताता है एविडेंस कैसे लिया जाएगा?
नहीं.
देन हाउ इट इज प्रोसीजरल लॉ?
Sir, it's more of an adjective law, so I thought it's a
So it should have some procedural nature in it.
Yes, sir.
What are those? Okay. Shashwat, when we started with your interview, we talked about honesty. So during the interview, I found out that you are not honest. Because when I asked you about one of your qualities which is not suited for being a judge, you told us that you want to live in a place which is more urban kind of, और आप ऐसी जगह पे रहना चाहते हैं जहाँ पे ये सारी चीज़ें अवेलेबल हो. एंड व्हेन सर ने आपसे पूछा कि आप डीजीएस ज्वाइन करेंगे या कहीं और स्टेट में, देन यू प्रेफर्ड दैट यू विल ज्वाइन डीजीएस, क्योंकि आप चाहते हैं एक अर्बन जगह पे रहना, एक अर्बन प्लेस पे रहना, एक मेट्रोपॉलिटन प्लेस पे रहना, इसलिए आप डीजीएस ज्वाइन करना चाहते. और आपने बोला कि मैं ये क्वालिटी अपनी सेक्रीफाइस कर दूंगा फॉर बीइंग अ जज. But we can see from your answers that you are not ready to sacrifice this quality of yours.
But if I'm given an option, then of course I would not want to. But if there is no option for
this board has presumed that you are not honest. The presumption has arisen. Okay.
Thank you.
Shashwat.